Hi, I'm Nancy Vettorello, legal practice professor at the University of Michigan Law School. And in this segment, I'm going to talk about the sources of law and the court system. There are four primary sources of law, including the Constitution, statutes, regulations, and the common law. Each state has its own set of these laws, and the federal government its own. Despite what you might have learned in grade school, that only the legislature makes laws and that the executive enforces them and the judiciary evaluates them, all three branches of the government make law. For example, the legislature makes statutory laws, which are probably the laws you're most familiar with. The executive branch makes regulations. The executive branch, through its departments and agencies, and you have an example here of the Department of Justice and its various agencies, 59 in total, are charged with implementing or enforcing a statute. The regulations are the specific rules by which they do that. For example, Congress has passed a statute providing that a prisoner is to be released upon the expiration of their sentence. But Congress also gave a specific agency, in this case the Bureau of Prisons, the ability to create regulations to enforce that statute. And therefore, they did create that regulation, and it states that if the release date should fall on the weekend or a holiday, the release of the prisoner would be allowed the week before. Lastly, the judiciary creates common law. The court really has two separate functions. First, the court evaluates and interprets the Constitution and statutes. But second, the court develops and applies the common law. The common law fills the gap left by statutory law, and it relies on custom rather than statute. Three prominent areas of the common law include property, contract, and torts. And because those areas of the law are largely governed by state law, most of the common law in the United States is state law. Let's turn now and look at the court system. The federal government has its own court system, and each state its own. They're separate systems with a separate set of cases that they decide and separate courthouses. And that's well illustrated here by this map of Ann Arbor. The red arrow indicates the federal courthouse, and the green arrow, the state courthouse. In case you're wondering, the blue arrow points in the direction of the law school. Separate systems, separate cases, separate courthouses. So how does a case originate in federal court versus state court? Well, federal court is a court of limited jurisdiction, and cases are appropriately heard there in only two circumstances. One, if the case involves a federal question, a question about the interpretation of the federal Constitution, for example, or a federal statute, it's properly heard in federal court. Second, if the litigants to the case have diversity jurisdiction, in other words, if the litigants are from two different states, the case can be heard in federal court, regardless of whether the underlying legal issues in the case are federal issues or state issues. State courts, on the other hand, are courts of general jurisdiction, and they hear by far the most cases heard in the United States. They hear state, civil, or criminal matters. A state court, however, could hear a case involving a federal issue, but only if that case involved both federal and state legal issues. So let's take a look at the basic structure of the federal court system, because it's a structure that many states follow as well. There's a single Supreme Court, 13 intermediate level appellate courts, and 94 trial courts. At the bottom of the structure are the federal trial courts, which are called district courts in the federal system. There's a district court in every state, although the district court boundaries do not cross state lines. As you can see by the graph here, Michigan has two district courts, the Western District of Michigan and the Eastern District of Michigan. The district courts represent the starting point for most federal cases. If litigants are unhappy with the decision of the district court, they have the right to appeal. Those appeals are heard at the federal appellate courts, called circuit courts. There are 12 regional circuit courts, and they're referred to by number, and you can see some of the numbers here on screen. If a litigant in the district court, in one of the district courts of Michigan, wants to appeal her case, she appeals her case to the 6th Circuit, as would litigants from district courts in Ohio, Kentucky, and Tennessee. The 13th Appellate Court is the Court of Appeals of the Federal Circuit. That court hears cases from across the United States, but only in specialized areas of the law, such as patent law. The top of the pyramid, of course, is the Supreme Court. Unlike appeals to the circuit courts, which are appeals as of right, appeals to the federal Supreme Court are by writ of certiorari or cert, as you'll most commonly hear. That means that the federal Supreme Court has the right to choose the cases that it will hear, and it only hears about 75 cases of the more than 10,000 requests that it gets every year. The Supreme Court also has original jurisdiction in just a few circumstances. For example, if two states were suing each other. Original jurisdiction means that the case starts with the Supreme Court and not one of the lower courts just described. Most cases come to the federal Supreme Court from the federal appellate courts, those circuit courts we just discussed. But it's also possible for a litigant whose case has been heard in a state Supreme Court to then appeal to the U.S. Supreme Court, but only if a substantial federal issue is involved. The court structure of many state courts looks just like the court structure of the federal courts, and Illinois is a good example of that. It has multiple appellate courts geographically divided. Other states, however, like Michigan, have only a single court of appeals, a single intermediate level appellate court. Though the structure looks a little bit different, it's still a hierarchy, and that's critical to know. A few other differences between the federal court system and some of the state court systems. One of the most critical is the name of the courts. In the federal court system, the circuit court refers to that intermediate level appellate court. In Florida, and actually many states, circuit court refers to their trial court. And in New York, the trial court is named the Supreme Court, whereas their highest court is called the New York Appellate Court. So it is critical to understand which level of court you're in when you're reading a case. And the name doesn't always provide that information for you. 10 states, including Nevada, as seen here, have no intermediate appellate level course. That means there's only a trial court and the Supreme Court. Texas, on the other hand, has 2 Supreme Courts, one for civil cases and one that's reserved only for criminal appeals. And finally, most states have courts of limited jurisdiction, specialty courts such as probate and small claims. Understanding the structure of the court system is critical to understanding how courts make their decisions, and that will be the focus of the next segment.